You're listening to Soundside. I'm Libby Denkman. An ex-county clerk in Kentucky who drew nationwide attention for denying marriage licenses for same-sex couples is back in the news. Kim Davis is asking the Supreme Court to overturn its landmark decision that legalized same-sex unions nationwide. Obergefell versus Hodges was issued in 2015. It officially recognized that queer Americans have a constitutional right to get married. Hundreds of thousands of people have been married in the 10 years since, and also since then, Kim Davis has been fighting court battles over her refusal to grant licenses, citing her belief that she should get a religious exemption under the First Amendment. She recently filed another petition to the Supreme Court asking justices to hear her appeal and to overturn Obergefell. And we should say at the start that experts are skeptical they will take that up. But what would a serious legal fight over overturning marriage equality look like? And are legal rights besides marriage at risk for LGBTQ Washingtonians? Here to discuss is Professor Alison Gash, chair of the University of Oregon's Department of Political Science. She's also an academic expert in the United States courts, sexuality, same-sex marriage, constitutional rights, and public policy. Professor Gash, thanks for being here.
Thanks for having me.
So I mentioned experts are unsure if the Supreme Court would choose to grant the petition of cert that Kim Davis has tried to get a hearing before the court. What is the status of this case, and what do you think about its chances of actually being heard by the court?
Yeah, so it's a really great question, and I think that when we're trying to figure out whether the court is actually going to take on this case in a way that's less about the particular topic of marriage equality and more about the sort of technicalities of Davis's question. This case arose out of one couple who was denied their marriage license way back in 2015, right when Obergefell was ruled, and Kim Davis had essentially said, no, I'm not going to offer any of these marriage licenses. This couple had sued to have that marriage license provided, and then filed a separate suit seeking damages for her denial, essentially. And so this case and they won, right? And so this case stems from those damages. So Kim Davis has consistently appealed the damages that they're entitled to as a function of a jury trial that occurred. And so this is what this is. She doesn't want to pay the damages. And so she's appealed it. And at no step along the way has any judge ever said, you're right, you don't have to pay the damages. She's making an argument essentially that she should be exempted from having to pay these damages because she was protected by free exercise from having to provide these marriage licenses. No court has ever argued that she is in fact protected. They've argued, in fact, that when you are a public employee, when you represent government, you don't have free exercise claims in the context of that job. You can make those free exercise claims as a private citizen. But, if she's offering marriage licenses, if she's required to give those marriage licenses as part of her role as county clerk, she is not operating as a private citizen in that particular instance. And so this is what she's appealing ultimately to the Supreme Court. And we know, right, that, the attorneys that are representing her are essentially appealing this to the Supreme Court specifically because they want an actionable question that would allow them to say, we want to overturn Obergefell, right?
Can I ask about that, Professor?
Sure.
Because it's confusing to me why Obergefell would be at issue here when what she's talking about is her free expression rights as an employee of the government. That seems like a separate issue from equality in marriage. Like, why is Obergefell looped into this?
Yes, it's a great question. I think it's a question ultimately that the court is going to say, what's Obergefell doing here? Right? This is not even about marriage equality, right? This is simply about county clerk person did X, right? To protect their free exercise claims. right? This person was told to pay damages, right? So the sort of root cause of the damages, right? The root cause of what, ultimately inspired the jury to require her to pay damages is almost irrelevant because that issue has already been settled. And so I think you're right to be skeptical and confused about the role or the relevance of Obergefell, and in particular why it would require us to overturn Obergefell altogether. It is tacked on, right? It wasn't brought up in any of the other federal cases that preceded, right? The appeals claims that preceded this ask of the Supreme Court. And that's why I think a lot of legal experts are saying, like, this is not going to be the case ultimately that challenges Obergefell, because it does, right, the sort of legal argument about why one would need to overturn Obergefell to satisfy Kim Davis's claim, right, assuming that it even needs to be satisfied, which, again, is a question. So I think people are right to be skeptical. That said, right, it's a strange court at strange times. And it's not impossible that the court would ultimately agree to hear the claim. We know that by definition, so there's lots of different piles of cases that these cert petitions can end up in. One is an automatic denial. We know that hasn't been automatically denied. We know at least one judge is sort of interested in learning more. And so now it's in the pile of cases that may be considered. It's good to know that, the vast majority of cases that are in that cert pool, in that collection of cases that the court is considering to hear for the next particular term, the vast majority aren't heard, right? There's hundreds and hundreds and hundreds and hundreds of cases that make it to the court for their consideration, and the vast majority aren't taken. Is this the court case that's going to be taken? Probably not. But again, it only requires 4 justices to say yes. And we already know that we have 2, right? We already know Alito and Thomas are chomping at the bit to, to hear the case. But the question is, are there 2 more who would be interested in hearing this particular challenge to Obergefell? And that's the key, right? This particular challenge. There's going to be other challenges. Is this the one that they're going to want to hear?
And I guess the question for people who are watching the court's attitude towards Obergefell closely is, if they decline to hear this challenge from Kim Davis, does it signal that they don't have 5 votes for another challenge to overturn Obergefell? I mean, is the fate of this case necessarily indicative of the fate of a future challenge to Obergefell?
Not at all. Not at all. And that's the thing, right? So this particular instance may be just too far out of reach of the relevance of Obergefell, but that does not indicate the likelihood of a further challenge, a future challenge in some other context with some other facts prevailing, right? Prevailing either in being heard by the court or prevailing in terms of an actual reversal of Obergefell. I think this is going to be the first of many. The trick, right, with any case, and that's why the Davis case is really interesting, is in order for somebody to bring a claim, right, that references or that requires the court to take up Obergefell again, they have to have standing to do that, right? Meaning that they have to have, a sort of actionable question. They have to be experiencing some direct harm as a function of Obergefell versus Hodges. Davis has, in theory, right, and this is why they're really, wanting this to be the case that is taken, right? In theory, she's got harm. She's got this money she has to pay. They're making this argument that money is connected to the existence of Obergefell. I think it's a stretch, but that's the reason why they would like this to be the case, because she does have an actual harm to speak of. It's hard to figure out what a different kind of harm would look like, and that's going to be something that those folks who oppose same-sex marriage and want to strike down Obergefell are going to have to figure out. Like, what's their standing, right? What's their how are they going to bring a case that makes sense?
And I guess my skepticism about standing is that we've seen cases like the wedding website case, where somebody with a private business who made wedding websites had not even been asked by a same-sex couple to make a wedding website for them. But she was able to get to the Supreme Court challenging her right to deny services to somebody who had never asked her for services. So, like, this doesn't have to be somebody who's actually actively, involved. It apparently can be theoretical, which leads me to believe that there's all kinds of ways that Obergefell could be. I mean, where do you see the most likely challenge, I guess, coming from?
I mean, it's a great question, and you're right. It used to be the case that you had to make an argument that you're actually being harmed, right? That you didn't have some sort of prospective future harm, but that's changed. Again, in the context of marriage equality in particular, right? That's changed, and so it does invite, more people than ordinarily would be available to make a claim against Obergefell. It's so hard to tell. I think state governments are, may just decide, we're going to start to pass laws that chip away at Obergefell, that chip away perhaps at the benefits that are, accrued to married couples, in particular to lesbian and gay married couples. And it may be that a challenge arises as a function of that state law, and then that state law ends up being sort of part of some sort of litigation that then brings Obergefell in. But it's hard to. It has to be a party that could be damaged or that is relevant, right, in the context of these marriage equality cases. There are, I think it's up to roughly 9, I think, locations in the United States, be they counties or, in some cases states, that are trying to actually pass laws that would then create a challenge for Obergefell. There are folks that are trying to do exactly that, but they haven't prevailed in terms of being able to pass the laws that would then provide the challenge. And again, that's why this Davis question is interesting, because it doesn't require a legislature to pass a law that would then be a challenge. It just, right, here's Kim Davis making this argument, and so they're going to use her because she's low hanging fruit in terms of effort.
What do you make of the other recent rulings from the court when it comes to LGBTQ plus rights? I mean, I'm thinking about Mahmoud versus Taylor, the ruling that parents with religious objections should be allowed to pull their kids from school story time that includes books with gay themes or LGBTQ plus characters even. There are other ways that rights can be taken away, right, without seeing marriage equality specifically falling. What are you watching as the courts taking on these issues?
Yeah, I mean, Mahmoud is a really great example of, the power, right? The sort of prominence of free exercise in all of these LGBTQ rights cases. In a way, prior to Obergefell, free exercise didn't sort of have the same hold that it has today. And it may be that these free exercise claims have been strengthened, right, in a way because LGBTQ rights are perceived as a serious threat, right, to the capacity for folks to engage in the free exercise of their religious beliefs. And Mahmoud is a great example because here we've got, one of the books was literally a book about a child who was really upset that her uncle was getting married because she's really close to her uncle, and it meant that her uncle wasn't going to have enough time to spend with her. So she's all upset, why is, Uncle Bobby going to be getting married? And it turns out, right, that Uncle Bobby is marrying a man. And so there's one page in the book that talks about the wedding and, and how happy everybody is about the fact that Uncle Bobby's gotten married. Yay, because that's what people do at weddings. They celebrate. And Alito, who wrote the opinion, makes the biggest deal about the fact that people were celebrating these nuptials, and essentially argues that the fact that people were celebrating means that the book itself and the fact that it's being read is coercive, right? That it's attempting to push people into supporting same-sex marriage. Right. The reality is the fact of the marriage being same-sex nuptials is really sort of the sideshow to this
it's incidental to the plot of the book.
It's completely incidental, right? It's like you could have the same book right, without the fact that it's a gay married couple, and it would literally be, articulating the same thing.
But it
So
acknowledges the existence of gay
but
people and gay
acknowledges,
couples.
yeah,
Yeah.
yeah. I mean, it's lovely, right? They throw it in there because it's normal to have gay marriages, right? But it's not about same-sex marriage in the slightest. And he makes this really big deal about the fact that it's an obvious. It's not even like it's right. It skirts the edge. He says, right, this is a real obvious, clear example of the sort of coercive capacities of these books. Which clearly requires people to have room to exercise right their religious beliefs, right, and therefore to require the schools to allow parents to opt their kids out of hearing these books. And so that should be concerning, right, for LGBTQ rights advocates, because the space now, the prominence, the privilege, right, that free exercise has, right, that folks have when they're claiming those free exercise rights relative to specifically marriage equality, is profound. And the reason why that's concerning in particular when we're talking about Obergefell is that Roberts dissented in Obergefell. Roberts, he has since supported some sort of elements of Obergefell
He's
as
supported
precedent.
rights of same-sex couples to in adoption, right?
And,
And so,
right, to be listed
yeah.
jointly on their birth certificates, right?
Hmm.
But in Obergefell proper, right, he specifically dissented specifically because he was worried about the free exercise claims that would arise, right? The free exercise curtailments, constraints that would arise as a function of the existence of marriage equality, right? And so here we have this string of cases, right, that is not just articulating, right, this possibility of free exercise being an issue, but really expanding the space that it takes up, specifically in the context of same-sex marriage. And so I think there's a worry there about the sort of space that holds.
If Obergefell were to eventually be challenged and is overturned by the new makeup of this court, what does it mean for places like Oregon and Washington, the Pacific Northwest? What would it look like in our local municipalities and governments if Obergefell goes away?
Yes, that's a great question. And in a way, we're in a better situation than we were prior to Obergefell, specifically because under Biden, the Respect for Marriage Act was passed, and essentially this act, first of all, what it does is it allows for same-sex couples to absolutely be guaranteed federal benefits under the law if they are married, right? And it strikes down the Defense of Marriage Act, which essentially withdrew those benefits. And then it also says that if a married couple, if a gay couple is allowed to get married in a particular state, it means that other states have to recognize their marriage, right? It doesn't require that all states sanctify or recognize or provide marriage licenses, but it does in fact require all states to recognize same-sex marriages that exist from other states or other locations. So if you are in Arkansas and you can't get married, you can go to a state where you can get married, and Arkansas needs to recognize your marriage. And so that puts folks in a much better place than they were prior to Obergefell. And what that means for folks in Washington and Oregon and California and other places that have more liberal policies around queer rights, around trans rights, is that likely it's not going to affect folks in those places. As soon as Obergefell is overturned, the big question is what happens if you are a state that doesn't have legislation that says that they will provide marriage licenses. For a lot of places, Obergefell just essentially overturned all of the existing bans. So those bans are still in place, right? They're just not legally recognizable because of Obergefell. If you get rid of Obergefell,
Kind
those
of like
bans.
Dobbs and,
Yeah,
overturning Roe.
exactly.
Yeah.
Exactly. Right. When you would see these like ridiculous laws from the 1800s suddenly being, applied, this is exactly the situation we're in. And so, and in more liberal places that would have legislated, right, these rights for gay couples, you might see right, some extra steps being taken to make sure that they are legislatively secured, or even better, secured in their state constitutions. Oregon, for instance, has a ballot initiative that's going to be on the ballot, I think, in November, that does exactly that, right? That makes sure that in the Constitution we are protecting marriage equality. I think that's happening up and down the West Coast. And so if those pass, which they will, it'll mean that those states, right, Washington, Oregon, California, et cetera, will have protected marriage rights for queer and trans couples. So it means that we'll be able to get married here, and it also means that it will have to be recognized at the federal level. It also means that folks from other states where it isn't legal could come over here, get married, go back to their state, and have it recognized, at least in theory. So, so it's not to say that it's not bad. It's difficult for a lot of couples to have to do that, right? The sort of center area, right? The middle area of the United States is covered with these bans, and it's not clear how easy it's going to be to get rid of those in those places. But it's not going to be as bad as it was prior to Obergefell, at least in theory, right? Because the Respective Marriage Act exists.
But it would result in basically another example of a patchwork of rights
Absolutely.
in this country, in a really stark way, this similar to what we see with Dobbs. Professor, before we go, I'm just curious about the popular opinion angle of this, because, even between 2015 and now, the support for same-sex marriage has increased across the country. 67% of Americans support same-sex marriage, according to a survey by the Public Religion Research Institute. Does the court respond to public opinion? I mean, does it matter that gay marriage, rights for LGBTQ plus Americans are very popular?
I mean, does it matter? It can matter. It matters when the court wants it to matter, right? Take Dobbs. Great. Dobbs is a great question. The support for some form of access to abortion was very popular when Dobbs was ruled. And so the question of whether public opinion directly matters, it doesn't always, right? Sometimes it does, sometimes it doesn't. And it's complicated because at the time that Obergefell was ruled, right, one of the other aspects of the Roberts dissent and aspects of other dissenting opinions was we should let the legislative process, bear this out, right? This is something that, right, that people are sort of mixed about, and so we should let the legislative process deal with this question, which of course is a reflection of public opinion. If there is an argument to be made about public opinion in the context of marriage equality, it would be very easy for the court to then say, hey, right, we can now speak to a public process, right, that could conceivably reflect the changes in opinion that have occurred, right, over the last 10 years, right, and thus we should allow for the public, right, process, for the legislative process to work this out. Roberts could very easily point to the existence of the Respect for Marriage Act as an example of exactly that process working, and thus remove the protections of Obergefell, remove those sort of training wheels, if you will, and allow the legislative process to work itself out. So like the relevance of public opinion in this particular story doesn't cut in the direction of, so they'll keep Obergefell, right? It actually could cut strangely in the direction of, so now we can remove these, right, these problematic, right, judicial protections and let the legislative process work itself out. And I actually think that is probably something that will be considered if there is a realistic challenge. But yeah, the public opinion story is, how the court uses it is always sort of a big giant question mark.
I really thank you for your perspective on this, Professor. And again, even if the Kim Davis challenge is a long shot, this question of what the future of marriage equality looks like is a very live and active one in our judicial space. And I thanks again for walking us through it. Professor Alison Gash, chair of the University of Oregon's Department of Political Science. Really appreciate your time today.
Yeah, thanks for having me.
Thanks for listening to Soundside. This show is only possible because listeners support us. If you're able to give right now, please check out the show notes for a link to donate. And don't forget, you can listen live on KUOW 94.9 FM Seattle at noon and 8 p.m., Monday through Thursday, or anytime online at KUOW.org.